is Section 14, second class of Section 14, which will also be an abbreviated class, but we're dealing with constructive trusts and resulting trusts. And the next case in the sequence is Fortin versus Roman Catholic Bishop of Worcester. And it deals with a few interesting issues that we should think about. So it's not just about trusts with respect to a resulting trust and a constructive trust.
You started?
Yes.
I apologize, I'm out of here.
Okay, Judge, I'll see you. But it also deals with the whole idea about ecclesiastical controversies, which is something we don't oftentimes talk about in law school. And so Fortin has an interesting background to it, and you really should look at it in depth, because it talks about the First Amendment, which as a general matter is going to protect churches with a hierarchical structure from being subject to suits in our civil courts, our federal and state courts, if in fact the controversy deals with what we call church matters, the business of the church, unless we can apply neutral principles of law without potentially disturbing church policy and church matters like that. And so the first part of it to think about from the standpoint of under what circumstances we have to defer to the structure of the courts of a church or of an organized religion would be, it depends on whether it has this hierarchical structure. And all that really means is, just as we think about our own courts, where we have a trial court, we have an appellate court, and then usually we have a final appellate court, that there is a structure like that that applies to the church as opposed to a congregational structure. So if you think about it from the standpoint of the court system, we know we have the trial court, the appellate court, and then ultimately usually a Supreme Court in the state, same thing in the federal. If we apply that to churches, we think, well, there is a parish level of religious officers or entities that serve the community. From there, then, though there are bishops and the like who are supposed to supervise those activities, and then ultimately all of those activities are supervised by the Pope. That is the type of structure that would in fact allow the religious organization to obtain the permission, the protection of the First Amendment, such that its practices, to the extent they are part and parcel of that religious entity, then if they are policies and practices of the religious organization, then they are protected by the First Amendment, so that in essence you can't sue. In the civil courts, you're left to those processes that we all don't know much about. But the first one here is, in fact, they want to close down a church, which for the most part would seem to be the religious organization has the ability to decide how to run its organization and the like. But the parishioners don't want the church to be their church, which for many people is a significant part of their lives. They don't want their church, their entity closed down, and they want to have some say about it. So the first part of the problem is the court has to struggle with whether it can even entertain this controversy, or whether it in fact is protected by the First Amendment from our courts from being able to examine whether there are even any claims here. And so we first start with figuring out what type of structure the court has, if it, or the religious organization have. If it has a congregational structure, sort of a flat structure, there is no protection for it from the First Amendment. It has to have this hierarchical structure in order to obtain protection for what they say are ecclesiastical disputes concerning what I'm going to refer to as church matters. So these folks said they go to court. What they're saying is the church is wrong here. This is the Roman Catholic Church. They're wrong to try and shut down our church. They promised us if we raised money, if we were supportive of the church and its priests and the like, they would be here for us in our time of need. So what they do when they realize it's closing, and this has happened in a number of different communities and a number of different organizations over the last, say, 15 years. There have been parishioners who have occupied churches to try and protect it from being closed. There are many people who have fought the church in trying to protect what they see as their local church. And here, these folks who are down the street from, well, no more than down the street from us, but it also happened in Lowell as well. They brought suit in the Superior Court. They don't want their parish merged. And they say there's a breach of contract here. And that they want specific performance of the contract. They want declaratory judgment. And they're also going to argue that they should have either a resulting or constructive trust over the church based on the money that they raised, the promises that the church made in return for all of that. And so the first thing we have to decide is this even something that our civil courts can entertain, or are the parishioners left with a relatively useless remedy, which would be, you have to sue the church in its own courts in a relatively private, secret proceeding that doesn't promise the best of due process protections and the like. So the first part of it is, the problem is this protected by the First Amendment such that we can't even look at it? Because look what happened here. If this happened with anyone other than a religious organization, you'd say, well, Jesus, this sounds like a 93A or consumer fraud issues. It says, the school congregation, the Bishop of Springfield, jointly mortgaged both parcels as a security for $325,000 note. The parishioners then funded the construction of the building, which cost over $1 million. This served as their house of worship until the church decided to merge it. And so they then, in May of '91, they told them there are some problems with this church, there's problems with the building, and we're told that if you can raise 1/2 of the funds needed to repair the church, the dioceses would lend the parishioners the remaining funds, and the church would remain open. The plaintiffs claimed to have raised pledges of over $600. The bishop said, you know what, I'm going to merge it anyway, and so they filed suit. And so that's the question is, well, why shouldn't they be able to sue like we'd be able to sue anyone else? If you made promises and in return for those promises we have done certain things, why couldn't you be sued, and shouldn't you be subject to, in this case, Massachusetts laws, one of which would spring readily to mind, which would be 93A, consumer fraud type violations. You said if we did X that you would do Y, we've done X, and now you say, well, it doesn't really matter. And so they've got to decide, and they're arguing that either through a theory of resulting or constructive trust, we now have ownership to the property. So we've got contract claims, we've got promissory estoppel claims, we've got requests for specific performance, and we have questions of a resulting trust or constructive trust. So we've got an awful lot of arguments, an awful lot of issues in a relatively straightforward case. The first thing they do, as they say here, is we've got to get around the question of the First Amendment. And what it says is the First Amendment prohibits civil courts from intervening in disputes concerning religious doctrine, discipline, faith, or internal organization. So is this potentially a matter concerning religious doctrine, discipline, faith, or internal organization? And here's the thing I need you to think about in this regard is it doesn't necessarily have to be a mainstream religion, right? If the religion is organized in such a way that it has the appropriate structure, the fact that their religious doctrine or policies or views may seem unorthodox or odd to us doesn't really matter. The fact is they would still get that First Amendment protection. And that's what's important to think about here. I think sometimes we look at it and say, oh, it's the Catholic Church, oh, it's the Jewish organization, or it's the Episcopalians. You say, oh, okay, it's a long organized religion. Any religion having this structure, the First Amendment is the freedom to subscribe to religions of our choice, not your choice, not what someone else sees as odd, because every religion has odd practices to others. I mean, if you think about it, the Catholic Church, and I'm Catholic, so I'll pick on them. You know, we say that priests can't marry. And priests and nuns have to be celibate for the rest of their life. If this was some sort of cultish thing, you'd say, well, that's a pretty odd thing to require someone to do as a matter of religion. But my point for you to think about is, well, so we don't get to pick which religions we give this First Amendment protection to if they have the appropriate structure. The fact is they'd all be entitled to it because it's the freedom to subscribe to religions of our choice, not the state's choice. And so here, the fact is they're going to have to examine it just as they would with respect to any entity, not just that, oh, the church knows best, which these days we know that's probably not true either for reasons that have been well played out over the last 15 years with respect to the church's own problems as well. Yeah.
So with religions where men are allowed to have multiple wives, does the First Amendment...
Well, First Amendment isn't going to protect polygamy.
Right. Exactly.
Right, no, it does not protect it. But that's a matter for your con law professors as to why. Well, you know what, though? It's got to be that the state's interests there are greater than the First Amendment, because there are some religions, I believe, that say it's okay to take a wife at 8 or 7. Sometimes it's a similar thing. Well, clearly the state has an interest in protecting children as well. So, but children I have a greater comfort level with. I wonder why the First Amendment doesn't necessarily protect polygamy.
Because if we go on this basis
Yeah.
of this argument, that technically speaking, that belief, not
That-
the public's belief,
Right.
our belief.
I am with you. I don't understand. Well, I just don't know why the exception is. What I know what they're going to do here with respect to the real estate is they're going to say, well, listen, if we've got to get into church doctrine or church policies, we're out because we don't have that right. Now, Ray points out, well, why do they have that right when it comes to marriage? But they do. There's got to be somewhere there. But at any rate, here they're going to say, is there some way to resolve this using what we call neutral principles of law? Meaning not involving church doctrine, but really looking at it from the standpoint of contract law or resulting trust or constructive trust, the actual law. And as it says here, right, if the court can use it, it can adopt neutral principles of law to resolve church property disputes, and that may be when we're looking at it, this is a property dispute. Thus, if a dispute can be resolved without inquiry into matters of religious doctrine or polity, a court may examine such sources as statutes holding property, the Constitution, bylaws of the religious organizations involved, the deeds to the property. Let's see if we can do it without touching on on doctrine. And obviously the structure of the church is important as well. And so the first part of it is the Roman Catholic Church qualifies as a hierarchical structure. It has just what it says here. It maintains an internal system of tribunals for resolution of disputes. So just the fact that we're not familiar with it doesn't mean that they don't have their own canon law and their internal dispute resolution process, which includes rights of appeal and the like as to how those matters proceed. And so then they decide, well, it's got structure. We're going to have to see if we can use neutral principles of law to resolve this. And again, to me, it's kind of interesting because if it was some entity other than a religious organization, you would start to be concerned about whether there was fraud. But you still, even if there is, you have to try and see, well, under what circumstances would these folks be entitled to any relief? And so on page 789, it gives you a really good definition of a resulting trust and a constructive trust. And so the language on 789 of the actual decision is important. And the court is going to dismiss both of these claims before we're done. But first they take a look at the resulting trust. And they say there's no basis for their claims that somehow the parishioners obtained a resulting trust in the conveyance of the parish. A resulting trust in real estate where arises where one party furnishes the consideration to purchase property, not intending a gift or advancement. Yes, title is taken in the name of another. So both of these, remember, are to avoid unjust enrichment. But if you're going to have a resulting trust at all, it has to arise at the time of the transfer where one party furnishes the consideration, yet title is taken into the name of the other. A resulting trust must arise, if at all, at the time of the execution of the deed. Did they furnish the entire consideration of the property? I mean, in essence, were they a straw man for the church? And I think the answer clearly is no. They did not furnish the entirety of the consideration here. They may have promised something towards it. And the second part of this would be problematic for them as well, not intending a gift or advancement. You know, the fact is that even to the extent they contributed to the purchase of the church property, they intended to donate that property to the church. They have, as the court said, no basis to establish the resulting trust. A resulting trust in real estate arises where one party furnishes the consideration to purchase the property, not intending a gift or advancement, yet title is taken in the name of another. In order to avoid unjust enrichment, it's important then that the court impose the resulting trust on the property to put the property in the name of the true owner, who's the person whose name, for whatever reason, did not appear on the deed, even though they furnished the consideration. So resulting trust is out. Constructive trust. Again, in order to avoid unjust enrichment, but we did this the other day as well, but here's the definition again. A constructive trustee for property can be declared for the benefit of another if the person acquired the property through fraud, mistake, breach of the fiduciary duty, or in other circumstances indicating that the person would be unjustly enriched. And this is Nesrela versus Peck, which is a pretty famous Massachusetts case we're going to look at in a minute as well. Again, did the church acquire the property through fraud, mistake, breach of a duty, or in other circumstances indicating that they would be unjustly enriched, such that it would be appropriate to impose a constructive trust on the property? And again, I think the answer is no. The court certainly feels the answer is no, that even though they may feel sympathy for these parishioners, they really, if we look at the law, there really is no basis for either a constructive trust or a resulting trust on this property. And these are important devices that you need to really think a little bit about, because we see it a lot of times. We see it a lot of times in real estate. We also see it a lot of sometimes in bank accounts. You know, an older parent says, you know, Johnny, I need you to put this money in your name in case I get sick. I can't then access my money to pay my bills and stuff. You take this $25,000 and put it, you know, we'll put just your name on it. Maybe they're doing it to try and avoid some of the Medicaid issues for nursing homes and the like, or whatever, or sometimes it's just to avoid access issues if they get sick, or even if it snows too much that winter and I can't get to pay my bills. And what happens then is the person who created that bank account dies, and now it's just in Johnny's name. But if Ma didn't intend a gift to Johnny, but somehow it ended up in Johnny's name, then you have an argument that potentially the court should step in and declare either a constructive trust or a resulting trust on the property. The first one would seem to what we described would be a resulting trust. The second one, you could argue even under the same set of circumstances, that at the time of death, he then acquires it through fraud in breach of the fiduciary duty. If it was understood that this never was your money, you should share it with your brothers and sisters. And we see both the bank accounts and the real estate issues as coming up a lot with respect to constructive trust and resulting trust. Because people think they can sort of make a homemade remedy for wills or trusts and things like that, and oftentimes it creates just as many problems on the back end that they were trying to avoid. But it happens with some real frequency. So we have Nessarella versus Peck. Again, real estate, and the question is, can we get a constructive trust or a resulting trust on the property here? The key to resulting trust, and if you think about it, is that the person who is the true owner, whose name is not on the deed, had to furnish the consideration, right? Oftentimes we refer to that as a straw man. Listen, Ray, I can't take this property in my name. I'm going through a nasty divorce right now. Put it in here's the money, put it in your name. You can convey it to me later on down the road. And then Ray forgets that was our deal. Well, then I'm going to go in and try and argue about the resulting trust. Under those circumstances, I got a little problem, because the first rule of equity, and these are all equitable remedies, is you got to do equity. If one who seeks equity must do equity. Jeeves points out that there's no writing that references this agreement, so how does that square with the statute of frauds? And that certainly would be Ray's argument, is that's what you say, is the writing. So you've got a couple of problems there, but nonetheless, I furnish the consideration, I want the property, and I didn't intend it as a gift. The only way now I might find my way back is by way of a resulting trust with respect to that property. So Nessarella versus Peck is again the same type of situation that we've seen before, where there's a Cumberland Farms dairy and convenience store. It was purchased as a straw. And I assume you've heard that reference before. That's just we're asking generally a friend, someone friendly, to hold the property for whatever reason. Sometimes it is legitimate. You know, if you knew Justin Bieber wanted to buy your property, the likelihood is you would charge a lot more money for that property because he can pay it. So sometimes legitimately they don't tell you who the buyer is, and either it's probably going to go in a trust, or maybe the attorney's going to take it in their own name, at least initially, so that you don't jack up the purchase price. And so sometimes there's not an illegitimate reason for it, there's a legitimate business reason. I mean, really, if I knew Walmart wanted to buy my property, the number's going up, right? And that's the point. So sometimes there is a legitimate, sometimes it's not, and that becomes probably, taxes, divorces, hiding bad money. You can argue down the road, that it was a straw purchase, but that potentially exposes other issues there as well. So it's just something to think about. But at any rate, so the question is, and the way this worked really, I do think, at least in part, it wasn't as sinister as to how it started, but then what they wanted was to get the court to step in and really decide what they should do with respect to the property. First of all, we've got a couple procedural problems with the case. The judge went from state court to federal court, and in that process, he did not make his findings of fact and conclusions of law before he left the Superior Court. We've talked about this a bunch of times. Under Rule 52, a case tried without the benefit of a jury, the trial court must make findings of fact and conclusions of law under Rule 52. We talked about why they have to do it, so that clearly, first of all, that the judge has really thought about what the facts are and what the law is that applies to those facts, and not just thought about it, but reduced it to writing so that they have seen it and we can see the justification for the decision. So in a jury waived trial, Rule 52 is fundamentally important. We've seen a couple of examples of it in the past. So I want you to remember that in this, someone was asking the other day, I think I've got to file a memo after this trial because the judge asked for it because it was a bench trial. No, it's not a memo then. What they're looking for, Rule 52, proposed findings of fact and conclusions of law. So I don't want to hear that you guys never heard about this, because I've probably done it at least 10 times already, right? So this one, the judge didn't make it. It's an error. Now this is a good judge, and they're going to try and help him out here, but this is a mistake. And yes, they don't get much secretarial help. They don't get much help at all. But the fact is that this should have been better done with respect to the judge's role. They're going to excuse it at the end of the day, but this is a mistake. Just as, by the way, just to be topical, just as the judge in Newton, who was charged, I assume you guys have heard on the way in probably, Judge in Newton and a court officer were charged with federal obstruction of justice because they assisted an immigrant to leave the courthouse without ICE, who was there to take him away, without ICE being allowed to take him away or even converse with him. So a judge, which is highly unusual, and the court officer have been charged with federal obstruction of justice and 3 other charges. I don't remember quite what they are right now, but that's a big deal. And the judge has now been suspended without pay already as well. So this is not going to end well for the court. And the U.S. Attorney said, well, regardless of whether you agree or disagree with the law, it is federal law. And it is problematic for a judge to assist in that regard, even though you could see where the sympathies might very well be for the people that somehow just got mixed up in our court system. My wife says they're in even probate court all the time. Sitting there, standing there waiting, or coming in when they know someone's got a case on. So, it is real that people's lives are being incredibly disrupted once they get in any involvement in the justice system, even for non-criminal matters. So, it seems kind of harsh that if you need the court's assistance on a family issue, that to go in, you risk potentially completely breaking up that family. But This was a criminal case in Newton, but the judge and the court officer now have been charged with federal charges.
So where's the law for a lawyer, right? That's your client.
Huh?
As a lawyer, and that person's your client.
Well, the lawyer wasn't charged, and the lawyer, my recollection, I didn't read the rest of it today. My recollection is the lawyer is the one that asked the court for the assistance. And I think the distinction would be, well, I am their advocate.
Right.
You know, so don't I have some protection there? But then the court went along with the request, or the judge went along with the request, and somehow the court officer must have assisted, and now those two are both facing, I mean, there's 4 federal charges, and federal sentencing guidelines are never good. I mean, they're bad. So it's kind of, well, not kind of, very interesting twist on the whole problem. But at any rate, so what the question is, Nesrela is saying that Peck holds the farm subject to a resulting trust, and that Peck was a faithless agent. That's Ray, who's not giving the property back when he agreed to before. But the court says that has no merit here at all. As we said in the last case, a resulting trust typically arises when a transfer of property is made to one person and the purchase price is paid by another. In that case, a trust results in favor of the person who furnishes the consideration. Nesrela provided nothing towards the purchase price of the farm here, and that therefore a resulting trust cannot be imposed for his benefit. The statute of frauds, as G's pointed out when we talked about the description, in the last situation, is a defense to his claims, sounding his contract, because there is no written contract that supports those claims. Peck is going to get to keep the Keck claims asserted against Peck are groundless. The property is going to stay the way it is. And the last case you have in this sequence is Divine. Episcopal Diocese of Mass versus Divine. And this is a straight one that the court says clearly this is a church matter. And there are no neutral principles of law that we can use in resolving this. If Divine has a claim at all, that claim is going to have to proceed through the church courts and ultimately be resolved within that structure of those courts. And so in essence, this claim cannot be examined by the civil courts, our state courts, or the federal courts. That claim falls clearly within church policy and their practices. And if you don't like their policy or practices, then you go to their courts. For instance, a nun couldn't sue for sex discrimination against the Catholic Church because the practices of the church are its policies and the like, and whatever remedy she may have is limited to the courts of the church and nothing else. I wanted to give you some time, so I'm going to cut the class short. I wanted to give you time to go over to the career fair, mingle and talk and do whatever you like. Hopefully get a job, or at least make some contacts that might be worthwhile. So I wish you good luck. Good fortune.